Hey, good morning, everyone. Thank you so much for joining us here today. My name is Ivan. I'm a counselor with SG Tech, and I'm very pleased today to be opening this session, renegotiating contracts under the new realigned framework of the COVID-19 Temporary Measures Act 2020. I know it's a mouthful, but we're so lucky to have Jonathan here, who will be excellent to bring you through this. All right, next slide. So before that, just want to give you guys some housekeeping rule. We will be recording this webinar. It will be available one day after on the SG Tech YouTube channel. So for those of you who need to reference back this anytime, we will have it available. Now, Q&A will be done via the Zoom Q&A function. Please indicate your company name and your name when you ask a question. We will answer the questions by Jonathan and SG Tech after the presentation is over. So click on the Q&A tab to be able to ask your question. I've also confirmed that we'll be able to give you guys the slides from this session after the webinar is over. So for you to get the slides, you have to fill out the Q&A form, the feedback form after the session is over. So if you want the slides from this session, please help us review this session after the session is over, and we will then promptly send you the slides. Now, for those of you who are new to SG Tech is the premier trade association for the tech industry in Singapore. We have 900 members all the way from SME to MNC to our startup itself. And being a member, especially if you're in the tech community, is so important as we are always stronger together. All right, next slide. So without further ado, I'm so pleased to have Jonathan Cole here from Withers and Tech to talk to you guys about this subject matter, about the COVID-19 temporary measures itself. Jonathan, over to you. Morning, Jonathan. All right, let Jonathan share the slide first. Yes, Jonathan, I think we can't hear you. Sorry. Yeah. And you can't hear us as well? Okay, guys, sorry, we have some technical errors.
Hello, can you hear me?
Okay, perfect.
Testing?
Yeah, we can hear you. All right. All right, Jonathan, I think you're ready to share your slides.
Hello.
Okay.
Okay. So I shall start the presentation. Give me a minute. Let me get a start. Slides up and running. Okay. Good morning. I want to thank SG Tech for inviting me to share this seminar on renegotiating contracts under the realigned framework that's being introduced under the COVID-19 Temporary Measures Act 2020. My name is Jonathan Koch, and I'm a partner in the law firm Withers Carter Wong. We are one of the largest firms in Singapore, and we are part of the Withers Worldwide law firm, international law firm. And we have 17 offices around the world. We are a full service firm in Singapore. And as you can see from the list below, we cover everything from corporate dispute resolutions, technology, tax, M&A, employment, intellectual property, insolvency, and funds. So I'm a partner in the intellectual property and technology practice, and we have this special interest group called Withers Tech. This is a special interest group that focuses on the tech sector, and we are able to provide a full suite of services from regulatory and licensing, funds formation, investments into tech companies, as well as helping companies manage their IP and technology and commercial transactions. So that's my area, really advising companies on commercial contracts. And that's why this area is relevant to me and to share with you, because this is an area, this realigned framework concerns commercial contracts, which a lot of my clients would have faced. So in today's presentation, what I want to cover is to explain the rationale behind the realigned framework. I think that's important because we need to understand where the government is coming from in introducing this framework and how it will apply to you and to the companies here in Singapore that can benefit from this realigned framework. So I will explain the rationale, and then I will go on to explain some of the detailed points within this framework. And the detailed points will involve, okay, which businesses are eligible to take advantage of this framework, and what are the eligible contracts that can be renegotiated under the framework. And the framework prescribes a very specific period within which you can initiate renegotiation. And renegotiation, as you will see later on in my presentation, includes termination of the contract. Okay, then I'll explain to you the process for initiating renegotiation of an eligible contract, and then what are the default terms of termination under the framework. And if there's disagreement between the parties, the matter can be referred to an assessor for determination, right? And so I'll also explain to you the process for submitting a application to an assessor for determination under the framework, right? So that's what I will cover in today's presentation. Now, just a quick brief description on what the realigned framework is all about. Now, the framework actually allows eligible businesses to renegotiate and rebase their contracts. And if they're not able to renegotiate or rebase their contracts, then the contracts may be terminated with prospective obligations extinguished. Prospective obligations means following termination, any of those obligations after the termination will no longer apply. So if you are thinking of terminating your contract, this framework will apply to you, okay? But the framework also provides for default terms of termination, right? And I will explain what those default terms of termination are, okay, under the framework. So first of all, let me explain the rationale behind the framework, okay? The rationale for this realigned framework. If you have been following what the government has been doing ever since the circuit breaker, they have introduced this COVID-19 Temporary Measures Act and granted relief for certain types of contracts. And the relief are that is a relief from having to pay or perform your obligations until, when it was first introduced, until September. Then it was extended to end of the year. And the applicable contracts were like hire purchase agreements, tenancy agreements, agreements in relation to events and weddings and tours and the travel industry. And so the government has been regularly updating these reliefs so as to avoid parties going into a dispute and allowing a framework where they can resolve matters between themselves. So this is a new initiative. Essentially is to allow parties to renegotiate a contract, because the contracts that apply are those that have been entered into before 25th March 2020, before the circuit breaker. So those contracts may have been negotiated under normal circumstances where you had thought with the other party that the contract would have been played out in a certain way if things went on as per normal. But because of COVID, the environment has changed. And now you find yourself in a different situation, whether you have faced supply disruptions, your deliveries, suppliers from overseas are not able to provide you with the materials that you require, and so on, or your business here in Singapore has been badly affected by COVID, your tenancy contracts, you can't pay the rents and so on. So COVID has changed the operating environment. So this framework gives parties affected by COVID to renegotiate their contracts to align the contract with current operating environment. So the framework gives the parties an opportunity to renegotiate their contracts or terminate the contract. All right. So broadly, that's the reason why there's such a framework being introduced. Right? Now, to be eligible to renegotiate under the framework, you need to be an eligible business. Right? An eligible business includes companies, LLPs, limited liability partnerships, sole proprietors, individuals like freelancers, and non-profit organizations. So it is quite wide. It covers almost every business type. But the thing is that you must qualify you must satisfy the criteria to be eligible to renegotiate under the framework. So first of all, you must not have an annual revenue that exceeds 30 million, right? And this is at a global group level. So the annual revenue of the business or group for the last financial year ending on or before 31st March 2020 will be assessed as to whether your annual revenue exceeds 30 million, right? So first of all, your annual revenue must not exceed 30 million. Then secondly, you must have experienced at least 70% fall in monthly average gross income for the period from 1st July 2020 to 31st December 2020. So that's the last half of 2020 compared to the same period in 2017. So the 70% fall in monthly average gross is in relation to the revenue that you have received in the second half of last year compared to the same period in 2019. Okay, so in order to be eligible, you must be a business that satisfies these two criteria. All right. Now, if you satisfy these two criteria, so you can then take benefit of the framework. But in negotiating under the framework, you can only negotiate contracts that satisfies the following conditions. Firstly, the contract must be governed by the laws of Singapore. Secondly, the contract must have been entered into on or before 25th March 2020. That was the date when the government announced the circuit breaker will kick in. And then at least one of the party must have a place of business in Singapore. And lastly, it must be a specified contract. Okay, so contracts must satisfy these four conditions. And what is a specified contract? Now, the framework prescribes that the specified contracts are leases for non-residential immovable property. Okay, non-residential essentially means any commercial property. Okay, whether it's a warehouse, retail shop space, or an office. Okay, but it must not have a term exceeding five years. Right. So it only applies to short-term, if you want to put it that way, short-term leases of not more than 5 years. Then it will also apply to hire purchase agreements for commercial equipment or vehicles, right? And then rental agreements for commercial equipment or vehicles. And lastly, the contracts for supply of goods and services. Okay. So these are the four types of contracts that are eligible to be renegotiated under the framework. So only if you have concerns or you have issues regarding your rental, your hire purchase agreements, or your rental of equipment or vehicles agreement, or the supply of goods and services agreement, then you can take advantage of this framework to renegotiate the terms of these contracts. Now, to be clear, the framework says that these contracts are expressly excluded. So you cannot renegotiate consumer contracts or employment contracts or insurance contracts or any financial contracts with banks or financial institutions. You cannot renegotiate construction and contracts. You cannot renegotiate contracts for carriage of goods by sea, land, or air. And you cannot renegotiate contracts for transfer of business as a going concern under this framework, right? So these are the excluded contracts. So if you are thinking of renegotiating any of these types of contracts, I'm afraid it has to be done outside a framework. You just have to do it directly with the other party and try to reach an amicable settlement, right? So what do you need to do if you are eligible under the framework to renegotiate those specified contracts? So this next section of my presentation, I will go through the procedure for you to renegotiate your contracts, the specified types of contracts under the framework. First of all, you need to know that there is an applicable renegotiation period. And this is only for 6 weeks starting this Friday, 15 January to 26 February 2021. This is a hard deadline. If you do not serve a notice of renegotiation before 26 February, then you will not be able to obtain any relief under the framework. So do bear in mind that if you want to renegotiate any specified contract under the framework, you must serve a notice of renegotiation starting this Friday and for the next 6 weeks until 26 February 2021. So that's the first point that you need to know. Now, I will just describe what is the procedure for renegotiation. Now, first of all, you have to fill up a notice of renegotiation form and set out your proposed revised terms in the notice of renegotiation, right? You can propose to revise the price or the rental amount. You can propose to revise interest rates. For instance, there's an interest rate payable for late payment or for outstanding amounts. Then you can, propose a revised interest rates, or you can propose to extend the time for repayment of outstanding amounts, right? Such as an installment payment scheme for the other party to consider. Or you can propose to extend or shorten the term of the contract. So for instance, it's a 5-year contract, but you feel that you only want to continue your business for the next 3 years under this contract, then you may negotiate for a shorter term of the contract instead of the 5-year term that's stated in the contract. Or you can negotiate to terminate the contract and propose what are the terms of termination for the other party to consider. So it may be a fixed term contract. So for instance, rental agreements, as you know, are fixed term contracts. If you have negotiated for a 3-year term, you are actually obliged to continue on the rental for the next three years. And if you terminate, the landlord is able to, during that 3-year period, the landlord is able to claim for the balance of the term. But here, under the framework, it gives you the opportunity for early termination, right? But on terms that are acceptable to the landlord, right? And you have to serve the notice of renegotiation, as I said, setting out your proposed revised terms or proposed terms of termination to all the parties that are involved in the transaction. And you must do it during the applicable period. That's to say 15 January to 26 February. In the case of a hire purchase and equipment rental contract, you have to use a notice of revision instead of the notice of renegotiation, okay? So once you have decided to renegotiate a contract, you have to serve the notice of renegotiation. And once the notice of renegotiation is served on all the other parties, you have 4 weeks to renegotiate the terms of the contract or the terms of termination if you are proposing to the other party to terminate the contract. So parties should use this 4-week negotiation period to try and reach an amicable agreement on the revised terms of the contract or the terms of termination. And during this negotiation period, there's actually a moratorium against either party taking any legal action on the contract. And any party who breaches the moratorium will be guilty of an offense and shall be liable on conviction to a fine not exceeding $1,000. Now, if the parties can reach an agreement on the revised terms or agree on the terms of termination, then the contract will be deemed to have been amended or terminated in accordance with the agreed terms. Okay. So that is the 4-week negotiation period where there's a moratorium and the parties are encouraged to negotiate and find an amicable solution to the contractual terms or even the termination of the contract. Now, if the other party objects to the notice of renegotiation, he can serve a notice of objection. But to serve a notice of objection, he must not only serve it on the other parties, but he must also serve it on the registrar of assessors. Okay, this is a court-appointed registrar, and he can do it. He can only serve the notice of objection during a 2-week period after the end of the negotiation period. Okay, so bear in mind there's a 4-week negotiation period where you have to negotiate. You can't object, or you either try and find a solution or you just, the other party might just keep quiet. That doesn't matter. But during that 4-week period, it is set aside specifically for renegotiation. Now, only after the expiry of that 4-week period, then the other party can serve a notice of objection, and he has 2 weeks to do that. Okay, following the expiry of the negotiation period. But the thing to note is that the other party can only object to the notice of renegotiation on 3 very specific grounds. Okay, the first ground is that he says that you are actually not an eligible business. So he thinks that you did not suffer more than 70% fall in your revenue last year, the second half of last year. Or he thinks that you have revenues of more than 30 million, quite unlikely, but more likely that you didn't suffer 70% fall in revenue. So he will object that you are not an eligible business. Or he can object that the contract that you are seeking to renegotiate is not a specified contract. So it is not a lease of a commercial property. It is not a hire purchase agreement. It's not a rental agreement, or it's not a contract for supply of goods or services. Or he can claim that you have served the notice of renegotiation outside the applicable period. Okay, so that's to say, if you happen to decide to serve the notice of renegotiation after the 26th of February, then obviously he can object on the ground that the applicable notice period have expired. Right. So these are the only 3 grounds he can raise an objection to. Okay. Now, one other point to note that so if you are disputing a tenancy agreement or you want to renegotiate a tenancy agreement and you are proposing to have an early termination of a tenancy agreement, then you serve your notice of renegotiation to the landlord. But the landlord may agree to the early termination, but he may wish to seek compensation for early termination. And that's because, well, he may accept termination. Let's say he agrees that it will be terminated at the end of February, all right? So, but the contract, the tenancy agreement is supposed to run until end of, let's say, 2022. So he would have lost the opportunity to collect rent from you for the next 1 year and 10 months. And so he thinks that he will suffer because he is not able to get a replacement tenant. Then he can ask for compensation for you. Of course, he cannot ask you to pay up, for the rest of the balance of the tenancy period. But he may ask for some compensation, like he thinks that he may need 6 months to find a replacement tenant. Then he will serve a notice of compensation asking for you to pay for the next 6 months or so. All right. So he will then serve the notice of compensation on you as a tenant as well as on the register of assessors. But if he thinks that he objects to your notice of negotiation, then he must serve the notice of objection. And as I said in the earlier slide, he can only object on 3 grounds, and that is that you are not an eligible business. But it would have been a specified contract because it's a tenancy agreement, or if you serve the outside. So he can, if he wants to object, he can only object on any of these three grounds. But very likely the only ground that he can object to is that you are not an eligible business to fall under the framework. Okay, before I move on to the next slide, I've made a note here that all forms under the framework will only be available for download from 15th January 2021. Okay, so Ministry of Law that introduced this framework in their website, they said that the forms are not available for download until 15 Jan. So that made it difficult for me to look at what the forms are, how is the format, and what the information you need to provide. So I'm not able to give you a sample of the form and share with you how you should fill up the form. That's something that you have to look through when the forms become available from this Friday onwards. But it's intended to be simple, because this whole process is not intended for you to engage a lawyer to act for you. It's meant to be simple enough for you as a layperson to be able to fill up and follow through the process. And that is why this webinar is just to introduce the framework to you, help you understand what is involved so that you can go about following the steps in renegotiating the contract under the framework. Okay. So bear in mind, there's always a 4-week negotiation period and a 2-week objection period. Now, many of you may be thinking, okay, I would like to terminate the contract. The termination provisions in your current contract may not be so favorable. And so that's why you want to take this opportunity to serve a notice of renegotiation to the other party to terminate. And you may want to propose certain terms of termination, right? Whether it's waiver of certain rights or certain that you have to pay the other party, or whatever it might be under the contract that is not favorable to you. You want to propose revised terms of termination, right? Now, the other party is meant to engage you during the renegotiation period to discuss the terms of termination. But if he does not respond during the negotiation period, or if he does not do anything during the objection period, the 2-week objection period, then the contract will be deemed terminated 2 days after the end of the objection period. Or if there's a date stated in the notice of renegotiation, then the date of termination stated in the notice will become the effective date of termination. Now, if you did not negotiate terms of termination and agreed to by the other party, then under the framework, there are default terms of termination. So in other words, if you come under the framework and both sides agrees to terminate the agreement, then the default terms of termination will apply, okay? If there's no agreement on terms of termination. So this is what Min Law has provided in relation to the termination of the default terms of termination. So here you can see that there are A, B, C, D in this infographic. Now, what the infographic will show you is that if it's Okay, just a general. If you look at A, B, C, and D, it will tell you that you have to pay for whatever is due to the other party up to the date of termination. All right, and so that's the general principle. So if you look at A, if you're terminating a lease or tenancy agreement, it says that the tenant must pay rent up to the date of termination and prorated if necessary. And then tenant must reinstate the premises in accordance with the contract and deliver vacant possession on or before date of termination. Otherwise, tenant will need to pay any sum set out in the lease agreement or compensate the landlord for any losses suffered. And the landlord can actually offset against the security deposit any damages or liabilities that you as a tenant owes to him. Okay, but he must return any remainder, the balance of the security deposit, within 4 weeks of termination. And then if you want to terminate a rental agreement for commercial equipment or commercial vehicles, then you must pay the rent up to the date of termination. And then you as a renter must reinstate the equipment or the vehicle in accordance with the contract and return the equipment or vehicle on or before date of termination. Otherwise, the renter will need to pay any sum set out in the rental agreement or compensate the supplier for any loss suffered. And the supplier can offset accrued liabilities against security deposit and any advance payment that has been made under the contract. But he must return any remainder within 4 weeks of the termination. And then for hire purchase agreements, you must pay all your installments due and payable up to the date of termination. And then you must also repay the sum of all installments, less interest for the remaining period of the contract after the date of termination, less the value of equipment assessed at the time of termination. And then you as hirer need not pay any early settlement fees and charges. And then hirer must return the equipment or vehicle to the owner on or before date of termination. Now, if you are terminating supply of goods or services, then you must pay for the goods already supplied, as well as expenses that the seller may have incurred in performing the contract up to the date of termination. For instance, you have to pay for cost of manufacturing the goods to be delivered after the contract termination, because that's expenses he had incurred prior to termination. Then seller can offset accrued liabilities against security deposit or any advance payments, but must return any balance within 4 weeks after termination. And then seller remains liable for any warranty issued in respect of goods supplied or services performed up to the date of termination. Okay. So these are the default terms if the contract is terminated during the renegotiation period. Okay. Now, assuming the other party does not agree to the notice of renegotiation, all right, and he raises an objection, okay, then what he must do is he must serve the notice of objection to you as well as to the registrar. And upon receipt of the notice of objection, the registrar will appoint one or more assessors to make a determination on the notice of objection. The panel of assessors are accountants and lawyers, so that's already set up. The registrar will then appoint one of them, whoever he thinks is most suitable to determine the issues, and appoint them to look through the notice of objection. Okay. Now, bear in mind there are two types of determination that the assessor can be asked to make. The first is the notice of objection. Okay. Another point, my bullet point 2 is that all determinations by assessor is free of charge, so you don't have to worry. There's no cost to be incurred on your part, no fees payable to have an assessor determine the issues. Okay. Now, the first type of determination that an assessor will be asked to make is firstly whether there are valid grounds for objection. Okay. And as you recall, I mentioned that the framework only provides for 3 different grounds of objection. One is whether the party is an eligible business. Second, whether the contract is a specified contract. And third, whether the notice of negotiation was served outside the applicable period. So very simple. For the notice of objection, the assessor just had to ask for the relevant documents, look at, are you a eligible business? Is the contract a specified contract? And was the notice of renegotiation served during or outside the applicable notice period? If the assessor determines that there are no grounds for objection, then he will put back to the parties and ask them, please negotiate and agree on the adjustment of rights and obligations upon termination of the contract, right? So here, the assumption is that the parties have decided that they will terminate the contract. And that's because the proposal for revised terms was not accepted by the other party. So the default then is that the contract will be terminated. Then the assessor will say, if he finds that this is a valid contract that falls under the framework, he will ask the parties to go and negotiate an adjustment of rights and obligations upon termination of the contract. So if the parties are able to come to an agreement on the terms of termination, then that will be end. But if the parties are not able to do so, then they can go back to the assessor. So this will be the second type of assessor's determination, and that is to ask the assessor to adjust rights and obligations upon termination. Okay, bear in mind, the assessor cannot negotiate or decide for you what are the revised terms. If you want to continue the contract, what are the revised terms of the contract? And this is because there's a principle of law that the courts or a tribunal will not get involved in commercial decisions. That is something for the parties to the contract to decide, okay? But he can only decide what is a fair adjustment of rights and obligations if the parties wish to terminate the agreement. So if the parties still cannot agree on the adjustment of rights and obligations upon termination, any one of the parties can file a notice of adjustment with the registrar to appoint an assessor to make a determination. Okay. Now, the notice of adjustment must be filed with the registrar within 7 days of the date of the first determination of the notice of objection. Okay. So if the assessor comes back on the first determination and says that this is a valid contract, you are eligible business, and then you have to quickly come to an agreement on adjustments of rights. But if you cannot do so, then within 7 days of receipt of the notice of the assessor's first determination, you must file with the registrar a notice for adjustment of rights and obligation. Okay. Upon receipt of this notice of adjustment, the assessor will look through the documents. He will conduct the hearing, so to speak, over emails, unless he's of the opinion that justice would be better served by having an online or a physical hearing between the two parties, right? But the intention is for this to be quick, short, and sharp, so as not to delay contractual obligations. All right. So the assessor will make a determination, and his determination is binding on all parties to the contract, and no appeal can be made against his determination. And once he has made a determination, it can be enforced with the permission of court in the same way as any court judgment or order of court. Okay. So his determination does have binding effect on the parties. Okay. Okay, so that really in a nutshell is the process under the framework. A applicable notice period, a 4-week renegotiation period, 2 weeks objection period, and then lastly, if required, determination by assessor. So that is really what the framework is about. Now, what I have next are infographics that will explain this process. And this is taken from the Ministry of Law website. But these slides will be sent to you, okay? These slides will be sent to you. So you can actually look through the infographics for better understanding of the process, okay? So let me go through the infographics for the renegotiation process. Okay, as you can see in the first line of the table or the bubble, the applicable notice period is 15 Jan to 26 February, right? So point one is an affected business that wishes to seek assistance under the realigned framework. You must serve your notice of renegotiation during this applicable notice period. Once the notice of negotiation has been sent out, you have 4 weeks to renegotiate the terms of the contract or terms of termination with the other party. So if you look at the left part, it says if you're successful, that's to say both parties agree on the amended terms or agree on the terms of termination, then that's the end, okay? That's the end. You need not proceed with the 2 weeks objection period. But if you are unsuccessful in renegotiating the terms or the termination of the agreement, then you look at this middle column. It says that if the other party does not object to affected business eligibility under the framework, then the contract will be deemed terminated 2 days after objection period ends. But if the parties cannot agree on obligations upon termination, then parties may lodge the notice of adjustment to the assessor. Okay, and then the assessor's determination will be final and binding as to what the rights and obligations are upon termination of the contract. But if the other party is a landlord, as I mentioned, he may accept that the tenancy agreement will be terminated earlier than the duration of the tenancy, but he may ask for compensation. And as you can see from 4B in the bubble there, it says that he can serve the notice of compensation, and the assessor can also take into account what compensation should be paid to the landlord for early termination. Now, in the case of if you want to renegotiate a hire purchase agreement, the process is very similar to the general process for all specified contracts, except that instead of a notice of negotiation, you have to serve the notice of revision, okay, to the other party. Then again, you have four weeks to negotiate. If you're successful, then the amended contract or payment reschedule will apply. But if you're unsuccessful, then you can raise this up to the assessor for determination, okay, whether it's a notice of objection or so it will be either 4A or 4B, whether the revised repayment schedule will form part of the contract. If the other party does not object to your revised schedule, or if he has objections to your eligibility to renegotiate the hire purchase contract under the framework, then he will serve a notice of objection, and the assessor will have to make a determination. Right. Okay, there's also one other category, which is in relation to renegotiation of essential services contracts. The only difference here is that if you look at the first bubble, point 1, it says that an affected business may begin to seek assistance under the realigned framework by serving notice of negotiation for contract of national interest on the other party or parties to the contract and interested to the contract. So the only difference is that in this second paragraph, it says that in order to be valid, a notice of negotiation for contract of national interest must be accompanied by a certificate issued by the relevant ministry certifying that the contract is of national interest. So that's the only difference in relation to a contract for the provision of essential services or affecting essential services or is of national interest. You need a certificate from the relevant ministry to certify that it is a contract of national interest or for the provision of essential services. Then the rest of the procedure is the same. 4 weeks negotiation period and 2 weeks repricing period. Okay. So all this information is available from the Ministry of Law website. I'm not sure whether other agencies like ASME or any other agencies have come up with a brief of this realigned framework, but in any case, they would have to get all their information from the Ministry of Law website. And here I've given you the URL where you can actually go and read in the details of the framework. So it is found in the Min Law website and under the link to the realigned framework. Okay. So I hope, yeah, this brief presentation has helped you to understand what the framework is all about, the rationale behind it, whether you are eligible business, whether the contract that you intend to negotiate is a specified contract, and then the procedure to go about renegotiating a specified contract under the framework, and whether you need to get assessor's determination to resolve any issues that you may have with the other party under the framework. So thank you so much for your attention. We'll be taking questions from the participants, and then Jesri will be moderating the Q&A. Okay, thank you.
Thank you, Jonathan. Thank you so much for your detailed presentation. Yeah, so we will now open for Q&A. I would like to remind the participants, right, to actually submit using the Zoom Q&A function. So you can see on the bottom of your screen that says Q&A. You can type in your question. Please indicate your company name and your name when submitting the question. So right now we have already a few questions coming in for Jonathan. So, okay, we have a question from Guan Hyang. So, Jonathan, early on during your presentation, you have touched on the two criteria, right? For companies who, for eligible businesses that are applicable for this framework. So, for the two conditions, right, are they either or companies must fulfill both the condition? Jonathan, can you hear me? Oh, I think there's some technical issue on Jonathan's side. He will come in back shortly because I think he can't hear us, but we can hear him. Okay, just give us 1 minute. Hi, Jonathan.
Okay, sorry, just now.
Yeah, no worries. Can you hear me now?
Yes.
Okay, yeah, that's great. So we already have a few questions coming in. So I will kick off one of them, which is this question is from Guan Hyang, right? So Jonathan, in your presentation earlier, you touched on the two criteria, right, for eligible businesses that can fall under this realigned framework. So for the two conditions, are they either or companies has to fulfill both of them?
Both. You must satisfy both criteria.
Sure. And in your earlier presentation, there's also the type of eligible contracts, right? So questions from Wei Xian. What is consumer contract? So Jonathan, could you give us some, more clearer definition, what constitute under the consumer contracts, and if you have any illustration?
Okay, so consumer contracts is an excluded contract under the framework. You cannot renegotiate consumer contracts under the framework. So what you want to understand is what constitutes or what are consumer contracts. It's essentially B2C contracts. So if you're selling to a member of the public, to an individual, and he's just buying from you because that's what your business is about, then that is a consumer contract. You're selling goods or services to individuals. Okay. But you know that an eligible contract is also a contract for supply of goods and services. Then that will mean a B2B contract. So I'm providing consultancy services to another business, to another company. Then that is a supply of services contract. Or I'm selling goods to another business, raw materials or equipment, but the other party is a company, a business. Then that will be an eligible contract because it's a B2B contract. So just bear in mind, B2B contracts come under the framework, but B2C contracts do not, okay, do not apply.
Okay, thank you, Jonathan, for the clarification. We have another question from Alvin. So how about security deposit? Does the framework cover anything regards to security deposit?
Yeah. So what the framework says is that if there's any monies owing, because the existing contract may say the security deposit will only be returned to you at the end of the contract, right? So in renegotiating the contract, you can say, okay, any monies I owe to the other party, I propose that you can apply the security deposit to pay up those amounts, right? Then you just return me the balance. So what the framework allows you to do is vary the existing terms of contract and to find an amicable solution so that you can part ways. Okay.
All right. And okay, earlier on because you mentioned consumer contracts are not are excluded from this framework. So I believe those home renovation contracts will not be eligible, right?
Yeah.
For renegotiation.
Yeah. So it's B2B or yeah. Actually, construction contracts.
Unless it's a commercial project, is it?
Yeah.
I see. All right, Ken. And we have a question from Lydia. So under a tenancy agreement, the landlords want to get full repayment for the deduction given due to the bill has passed. So what can we do under this realigned framework?
Sorry, this is a tenancy agreement.
Yes.
And then what does the landlord want?
The landlord wanted to get a full repayment for the deduction given because the bill has passed, right? And what can we do under this realigned framework?
Okay, so the realigned framework allows for early termination, even though the most tenancy agreements don't allow you to terminate until the full duration of tenancy expires. So it allows for early termination. And then, as you recall the slide I showed you, under the default terms of termination. So allow for early termination, but you must pay rent up to the date of termination, okay? So he cannot claim the balance, but if he feels that he needs to be better compensated, he can serve a notice of compensation. The landlord can serve a notice of compensation and ask the assessor to determine what should be that compensation for him. So I gave you the example that because you terminate early, let's say there's 2 more years to run on the tenancy agreement. So in other words, he's not going to enjoy rental for the next two years, but he thinks he may need another 6 months to get a new tenant, and to cover him for that 6 months, he may ask to be compensated for additional 6 months after the early termination. Okay, so that's just by way of example how termination of a tenancy may work out.
Okay, thank you, Jonathan. So there's another question. This is from Ali, right? Sai Ali. So he say, whether this law, right, does it apply to supply of goods and services with ministry or statutory boards?
Yes, so, yes, it will. Because
it will, yeah?
Yeah, it will.
Okay, good.
But like I said before, if it applies to, it will be considered then it may then be considered an essential service or national interest contract. That's where you need to get a certificate from the relevant ministry to confirm that that this is an essential service contract. So okay, but that doesn't, so you have to look at that carefully if you're dealing with government agencies.
Sure. And another question from Al Dizon. So were the points raised, right, under this framework, right, help to protect us from entities who may want to renegotiate with us?
Sorry, will the what?
So under this framework, will it protect, the law will protect entities who may want to renegotiate?
Oh, yes.
Yeah.
Yeah, for sure. So the point that I made about moratorium means that neither party can take any legal action against the other during the framework period, provided you have served the notice of negotiation. So once you serve that, the laws, in a sense, stops because you fall under the framework. Neither party can sue each other under the contract. You are required, once you serve the notice of negotiation, to come together to negotiate during that 4-week period. But if you cannot resolve, then, as I mentioned, there's the notice of objection after the negotiation period. And if you can't agree, then actually the default termination will apply.
Understand. So another question from Sunny. So were contracts that entered with corporate finance companies, right, such as for leasing of copier, right, this will not be covered under the Act, right?
Okay, actually, there's two points here which can be quite confusing. Okay, first of all, the easier point is that if it's a contract for hire purchase or rental of equipment, then it is covered. But then you say you actually get it from a financing company. Because financial transactions with financial institutions, that is excluded. Okay, so it must not be a financial transaction contract. But if it's a contract for supply of equipment or commercial vehicle, then yes, it's an eligible contract to fall under the framework.
Okay, noted. And a question from Estrella Ho. I believe with the renegotiation is not successful, it will not necessarily lead to termination of contract, right? So both parties during renegotiation can conclude to stay with the existing terms, which means there's no change.
Possible, yeah, possible that but you have to withdraw the notice of negotiation.
So which means that
that
there may be one party that wanted to renegotiate, and during this process, after whatever thing, and they decide not to.
Yeah, not to change the contract.
Then stay with the existing terms.
Yes. Yeah. Then they must file a withdrawal. They must withdraw.
Sure. Okay, noted. Let me see what other questions we have. Okay, from Eric, right? Can the notice of objection be served earlier than the 4 weeks of negotiation?
No.
No. So
no.
Okay.
You can only serve after the expiry of the 4-week negotiation period.
All right, and let me see what other question. Okay, because there's quite a lot coming in. That's great. Okay, there's a question from Vivian. Does the framework cover repayment terms, allow companies to prolong repayment terms under the current contract?
Yes. You can propose a new payment schedule. So if you remember one of my slides, it says that you can propose even to extend the agreement. So if the agreement is now for 2 years, you can actually extend it for maybe 3 years and then stretch the repayment terms. Or you can also ask for a lower installment payment or whatever. So it is flexible enough for you to propose.
Sure. And does this framework apply to actually working place? For example, if a tenant, they would like to terminate the contract early. I believe it may be like a co-working space or those kind.
Yeah, it will. I mean, co-working space is still at the end of the day a lease agreement. Yeah.
Okay. And from Lydia again, right? Eligible businesses must have 70% decrease in revenue from July to September 2020, when most businesses have resumed. Can we object if the significant fall is seen in April to June performance?
No, no. Because the condition is that the 70% fall must be July to December 2020 compared to July, December 2019. So it's a year-on-year comparison for the second half of last year.
All right, noted. And from Benjamin, right? Regarding notice of compensation, does it apply to all landlords or only small landlords?
All landlords.
Because he mentioned the infographic only mentions that small landlords are eligible for compensation.
Okay, even though yes, it says that, but the framework does not spell out what's a small, whether there's what kind of landlords are. So I didn't see any conditions for landlords to serve notice of compensation. Yeah, I can take a look again, but when I went through the information from MinLaw, it didn't say, I didn't pick up anything about what is a small landlord. I thought it applied to all landlords.
Okay, noted. All right, and another question from Estrella, right? I think this is an add-on to her previous one. What is the definition of the monthly average gross income in this framework? Does it include government grants?
Gross revenue. I think, if I recall correctly, it says, yeah, gross revenue. So if gross revenue is what you have been able to earn each month from July 2020 to December 2020.
So government grants it is more
No,
like
no.
a grant funding and will not constitute to the income.
Yeah.
All right.
Because grant is not income.
Okay.
It's just to offset it's just to help you out in payment of your expenses.
Noted. And from Kim Song, does this framework cover the lease of hire purchase of photocopier machine used for business purpose, not for personal? Yeah, as long as it's not a B2C, B2B contract will be eligible under this framework.
Correct.
And okay, there's this question from Iza, right? So he has he's a client of this CRM software where he has actually signed up or used their software for 3 years. He signed up for 3 years beginning December 2019. So they've paid in full fee, right, in advance in 2019, December 2019. So there are basically balanced 2 years remaining. But since March or April 2020, right, they try to negotiate with them, and I guess they refuse to they refuse to negotiate, and they has then suspend their entire access to the platform since November 2020. And they are like forced to migrate their data to use another system. Also, he want to know whether does this mean that the contract has been terminated since November 2020, and yeah.
Okay, so this raises a quite interesting question because it may mean that the DCRM, or I can't remember,
this company that's provide the
this
CRM
software
system.
company,
Yes.
This company, if they are in liquidation, and that's because you can't continue with them because they're in liquidation, then actually your advance payment, you have to file what we call a proof of debt with the liquidator to try and get back your money, because then it will be usually a contract will say that if one party is liquidated or wound up, then the contract is deemed terminated.
I don't think the company is being wound up, but I think probably the software company didn't want to renegotiate. And since then this company then they decide to actually suspend, right, the usage of this software. So
Okay. You can, assuming that the software provider is still around, then you can serve that notice of negotiation with them, because what you want is to terminate and then recover the advance payment that you have given to them, because you want early termination and then prorate your advance payment only up to the date of termination and then recover the balance. So the framework applies to that. Okay, but even though you have migrated and well, are using some other service provider, that doesn't matter, because your contract with this software service provider is still valid, and because you have paid advance for three years, you actually want to recover the balance, and that is why the framework will apply, and you should early terminate the contract under the framework and ask for the balance of the advance payment that you have made.
okay, so maybe for Isa, if you have any further question, I mean, we can link you out with Jonathan to see how he can assist further as well on this particular issue. And okay, and because we are running out of time, so we will end off with a last question. So Simon from the Marco, right? So earlier on your the criteria itself, you mentioned about the annual revenue, which is must not exceed 30 million, right? So the 30 million is under the group or the individual company who sign up for the tenancy contract?
Under the group. So if you in Singapore are part of a group, then the assessment is 30 million annual revenue for the entire group. Okay. But if you're a local company, then 30 million applies to you alone. Yeah, which most companies, SMEs, would probably satisfy. Yeah, but that is 30 million is a group level.
Okay, great. Yeah, so I think, right, we have most of the questions covered. I'd like to thank Jonathan again for coming in to share with us this detailed presentation on the realign framework. I hope our companies here have gained further insights, and it will help you in terms of your regards your renegotiation or of your contracts, etc. Right. So before we end off, right, I would just like to remind the attendees, right, to help us complete this short webinar survey. So this will help us to improve, the content for further session, right? And if you still have any questions with regards to, about this framework, feel free to also send them over. You can submit the either, because we will share the presentation slides that Jonathan has shared, which there's his contact details. Otherwise, drop us a note at info@sgtech.org.sg. We will help you to check in the questions with Jonathan and link you up with him separately. Right. If you have any other, if you are interested to find out more about SGTech activities, feel free to log on to our website and find out more about the upcoming activities. Right. So once again, thank you, Jonathan, for coming in to share with us. Yep. Thank you so much.
Okay,
Okay,
welcome.
that's all.
Thank you.
Yeah,
Thank you all.
thank
Bye-bye.
you.